Hello, everyone. My name is Alicia, and today I am joined by Richard of Richard A. Myers Jr. and Associates LLC. And this week in the blog, we are going to be discussing an important question. And Richard, that question is, can a facility discharge during a pending Medicaid appeal?
Well, they cannot. So that's probably one of the big notes we want people to take away from this particular blog is they're not allowed to discharge you while you have a pending Medicaid appeal. So often we'll see where facilities will threaten to discharge someone, or the one that we often hear is there's a long Medicaid waiting list. So if you can't apply for Medicaid here, you have to go someplace else. But once we submit that application, even if they tell you there's an extremely long waiting list, they are no longer under federal law allowed to ask you to leave. They can have a 2-year waiting list on Medicaid, but if you are in that facility and you apply for benefits, the community can no longer ask you to leave. So they'll threaten, but it violates federal law. So if there's a pending appeal, you're protected. So the 2 times you would be protected from discharge and not required to necessarily pay the full amount to the nursing home is if there's a pending application or if you're appealing a denial for Medicaid. They're not allowed to do discharge for either of those. But actually, one of the things that happened in our office was we actually changed law on this particular topic. We had someone who had filed for Medicaid, but the caseworker had made a mistake in their calculations. And so they improperly disallowed benefits when we were actually entitled to benefits. So we went in and the nursing home in Middleburg Heights tried to discharge our clients and actually won the hearing. So we had to take an appeal up to the Common Pleas Court. And what I told the Common Pleas Court was the 2 situations where you're protected is when there's a pending application or if you're appealing a denial. Well, this case, we're appealing an error. So the hearing officer said, well, that's not a denial. You're not entitled to protections. Well, we went up and I told the Common Pleas judge, which was Judge Villanueva, who's now retired, I said, when the legislature passed the statute, their intent was to protect people when there's a mistake by Medicaid. We can't possibly anticipate every error that a caseworker can make. So the intent was to protect when there's errors made, and the judge agreed. And he changed law in the state of Ohio that now if there's a legitimate error made by a caseworker, you're protected. So we were glad we fought the fight, and we serve a lot of people with that decision that was made because it's now recognized around the state. So worked hard, changed the rules a little bit so we can protect our clients and other people in the state.
Wow, that's really incredible that you were able to, step up to that level to make sure that you were able to protect your clients and then, people all throughout the state. That's really awesome that you were able to do that. And that just shows how much you care about what you're doing in your practice. So thank you so much for telling us a little bit more about that and easing the nerves of those who might be going through a situation like that. You know that there are options and simple errors can be made. So you're going to want to get in contact with Richard and his team to see how they can help you best. You can sign up for a free consultation by giving them a call. And make sure you're also exploring the rest of the website and the blog where you can have a lot more of your questions answered and find out more about how Richard A. Myers and his team can help you. Thank you so much.